Okay, we'll call the case of James S. Pendergraft versus Department of Health, Board of Medicine. Everybody get settled. You all ready? Okay, whenever you're ready.
All right. Good morning, Your Honors, and may it please the Court. My name's Lucinda Finley, and I'm here with my co-counsel, Kathy Kasperzak and Ken Metzger, on behalf of appellant Dr. James Pendergraft. I'd like to reserve 3 minutes for rebuttal, Your Honor. Thank you. Here, the Board's order must be reversed and the agency action found to be a gross abuse of their discretion because the Department of Health ignored the required willfulness element in the 2 criminal statutes relating to the practice of medicine that they sought to enforce, and they sought to enforce them as the adjudicator of first instance in direct violation of their own disciplinary statutes in the subsection C that limit them to acting only after the proper prosecuting authorities and the court system where the defendant would have received.
Ask you where the only after language comes from, because I couldn't find that in the statute.
I think it's a fair construction of the 2 subsection C, Your Honor, which as a penal statute, these must be strictly construed, which means that the department can bring disciplinary action only under the circumstances specified in each subsection of the disciplinary statutes. And subsection C says they can bring disciplinary action upon or after someone is being convicted of or pled guilty to or nolo contender to a crime directly relating to the practice of medicine.
And that's one of about a dozen ors. I mean, they can discipline for this or 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 this. You have the guilty plea, a criminal conviction, and then you also have that other section the department's relying on. And given that they're all ors, I'm having a hard time understanding why you say only. I mean, you add this only language, which doesn't seem consistent with the way the statute's constructed.
Well, I think turning to the subsections G and K that the department relies on, this general language of failing to perform an obligation, I think it's clear that their interpretation that that's a general catch-all that entitles them as the, in effect, trier of first instance to an administrative hearing.
That seems to be what the language of the statute suggests.
With all due respect, Your Honor, I would disagree. The language failing to perform an obligation in subsection K of 456.072, the legislature actually gives examples of what it means, such as failing to repay your government guaranteed student loans, failing to fulfill the service obligation that you agreed to do when you got a scholarship. These are specific affirmative obligations to do something placed directly on a licensee, which is obligation on a licensee is the language of subsections G and K. In contrast, the general criminal statute relating to the practice of medicine is a prohibition that applies to everyone, not just an obligation on a licensee. These criminal statutes at issue here apply to the unlicensed assistant who assists in the procedure, to an unlicensed person who attempts to do the procedure, to the medical assistant, to the friend who may assist. They are general criminal statutes that relate to the practice of medicine. They are not affirmative obligations such as those illustrated specifically by the legislature in subsection K that apply directly to a licensee. But, Your Honors, even if you conclude, despite the principle of strict construction and despite the statutory principle that you should not construe a statute to render subsection C meaningless, which the department's interpretation does.
I'm having a hard time following that. I mean, I think there are a lot of disciplinary instances in which the department's pretty much relieved of its, in other real estate license, all sorts of things, where the administrative agency is relieved of its burden of proof pretty much if there's a criminal plea or criminal guilty, because that's a higher standard of proof. So you can just take the conviction and discipline based on that without going through and proving any of the facts. But where the licensing agency is able to discipline for the same conduct, even if there's acquittal, even if there's no prosecution at all, that's just not an unusual concept. That's pretty typical of licensing.
Well, they're allowed to discipline for the same conduct if their disciplinary statutes permit them to. For example, the rape example that the appellee offers in their brief. It really isn't at all opposite to this case, because there is a specific provision in the disciplinary statutes in 456 that prohibits sexual misconduct by a healthcare provider and gives the department the authority to bring disciplinary actions. So when they bring a disciplinary action against a healthcare provider for sexual misconduct, they don't charge the offense of the underlying crime of rape in the criminal code and try to prove the elements of rape. They charge the offense of sexual misconduct contained in their own disciplinary statutes in 456. And that's the type of common occurrence that Your Honor is referring to. What happened here is actually unprecedented. I have not been able to find a single instance in which the department, as the court of trier of first instance, has completely bypassed the proper prosecuting authorities and used a criminal statute as the basis for the disciplinary charge. And then further...
but it's really an issue of statutory construction,
yes,
and not due process or separation of powers, as you suggest in your brief, because, I think you would admit that there could be language, catch-all language, that would allow a department to prosecute as a licensing matter, a discipline matter, a crime, irrespective of whether it was prosecuted by the state attorney's office.
It's primarily an issue of statutory construction, but I think due process concerns underlie why the legislature set the scheme the way it did. If you look at other parts of 456 here, particularly 456.066 and 456.075, they specify exactly what the department...
What's the due process concern? With your driver's license, that can be revoked for driving while intoxicated, irrespective of whether there's a prosecution. And I'm just not following why you have to have a criminal prosecution from a due process perspective in order to discipline conduct that's prohibited.
Well, the conduct is prohibited only in a criminal statute that says it is to be enforced by...
So it's just a statutory construction issue.
Yes, it is primarily...
There's no overarching due process reason why the department couldn't do this if the statute means what they say it means as opposed to what you say it means.
I think if the legislature said an administrative agency could adjudicate in the first instance whether someone's conduct amounts to a crime under a clear and convincing burden of proof and ignore the willfulness element, that would raise due process concerns. The sections I referred to a moment ago, Your Honor.
Counsel, what's your best case in support of your proposition that you have to get a conviction or a plea before you can take disciplinary action?
Well, admittedly, Your Honor, there's no case directly on point because this situation here is unprecedented. The department has never attempted to do this. I think one case that directly bears on the willfulness argument is this Court's own decision in the Kinney case, where they specified that was I believe, a real estate licensing, and they specified that despite a nolo contender plea to an underlying crime, the department had to prove the intent element in the underlying criminal statute, that they couldn't dispense with the intent element. And that case is directly on point to our argument that the department here cannot selectively ignore the willfulness element in the two statutes. I believe in a case that is relevant...
Let me ask a question to clarify something you said a moment ago. Are you saying that there has never been an action against a license based solely on subsection K of 456.072? No,
not on subsection K. That of course is charged frequently. I'm saying that these...
Well, that's what was charged here, right?
But it's the charge. Subsection K is just a pass-through. The actual charges brought were for violating 797.03 and 390.0111A One, there has never been a prior instance that I could find, nor the department cited in their brief, where those criminal statutes have ever been enforced in the first instance by the Department of Health using the general legal obligation, failure to perform a general obligation language in subsections G or K. I have not found a case where they have actually charged the criminal statute in the disciplinary complaint as the legal obligation that somebody failed to perform. So their theory here is that failing to comply with the criminal law, that every criminal law imposes an obligation on everybody to not violate it. So they are really stretching this failure to perform a legal obligation language to mean anytime we, the department, think you might have violated some law, we can bring disciplinary action. But the 456.066 says, the legislature says what they're actually supposed to do in such a situation. That subsection says if they suspect the criminal violation of a statute relating to the practice of medicine, they shall, not may, shall report to the proper prosecuting authority. And then 456.075 says that in a criminal proceeding, they can appear, assist, furnish information. Indeed, it says when the criminal proceeding relates to the qualifications, duties, and functions of a healthcare professional, the court can order them to appear and assist the prosecution. Nowhere in 456.066 or 075 does it say if the department suspects a criminal violation, they could refer it to the proper prosecuting authorities, or they could on their own use the general legal obligation sections of G and K and commence disciplinary proceedings. It instead says in 456C, after you follow 066 and refer it to the proper prosecuting authorities, if in the court of competent jurisdiction they get a conviction or a plea, then they can use C to bring the disciplinary proceedings. The entire statutory scheme here is very clear, and again, as a penal statute, must be strictly construed. The underlying criminal statutes themselves, 797 and 390, are also penal statutes and must be strictly construed, which means the department is not free to ignore the willfulness element, as they have chosen to do here. Further, I think another compounding problem with the charges brought here is the extremely dubious constitutionality of both the underlying statutes.
Let me ask you about willfulness, because I didn't want to interrupt.
Sure.
I want to hear what you had to say on the other issue. But I have a hard time understanding the issue there is a factual matter in this case. I mean, given that, there's not an issue that he accidentally didn't perform this procedure in a hospital all his conduct is willful here, and with the third trimester, the evidence was undisputed that he believed it was the third trimester. So it's factually, I don't understand where the issue is or where the argument would be that there was any non-willful, accidental, unintentional conduct at all. I just don't get that.
And willfulness, the department did not charge it in the administrative complaint and declared at the hearing that it was irrelevant. And by not charging it and declaring it as irrelevant, they deprived the appellant of the opportunity to even defend on the issue. Indeed, at the hearing, when counsel for the appellant attempted to introduce some evidence from the Department of Health investigators' notes that bore on the issue of showing lack of willfulness, the department objected and said it was irrelevant because willfulness was not an issue.
Did that evidence come in?
No. And on the argument of the department that it was irrelevant to these proceedings, the administrative law judge, the hearing officer, excluded the evidence. So there was, in fact, no finding of willfulness because it wasn't charged, and the department took the position, as they continue to maintain in their brief here, that it is irrelevant. So no, Your Honor, the evidence is not undisputed. And indeed, willfulness would have to apply to all the elements. It would have to apply that he knew to a reasonable degree, not just believed, but knew to a reasonable degree of medical probability that this patient was, in fact, carrying a viable fetus, which it's undisputed that it was not, and that it was past
Where
24
does
weeks of
that come in,
gestation.
the viable fetus?
Well, the department now in its brief, admitting the unconstitutionality of the two underlying statutes as written, says to save their constitutionality, you should construe them to apply only to viable fetuses. And yet, they neither charged viability here, they didn't attempt to prove it, and all of the medical...
I don't remember that argument. I thought the argument was that under Roe v. Wade and TW, in the third trimester, states are free to regulate, even prohibit abortion, so that really this isn't a constitutional issue, given that it only applies to third trimester procedures.
The way I understood the argument in their brief, well, first of all, under Roe or TW, a state cannot prohibit a third trimester procedure that's necessary to preserve the life or health of the woman. The way I understood their argument, they said that to be constitutional, to salvage their constitutionality, the statutes should be construed to apply under Florida law only to viable fetuses, because only when the fetus is viable under Florida law does the state's interest become compelling.
Do you recall where that is in the brief?
I'll ask my co-counsel to find the page and get it to you in just a moment.
I'm sure I can find it as well.
We will, and perhaps on rebuttal I can supply the page, and I'm sure the department will address it as well. But to relate it back to the point of willfulness, they would have had to allege and prove, and the hearing officer would have had to make a specific finding on willfulness of all of the aspects of the statute. Now, willfulness is also an element for a violation of the written certification requirement, 390.011. And again, they didn't allege or attempt to prove willfulness there, and they certainly couldn't, because even the ACCA investigator concluded that there were two written certifications. So how one could have concluded that Dr. Pendergraft knew that his chart notes and the referring physician's chart notes were not legally sufficient when even the ACCA surveyor thought they were, and the ALJ thought his chart notes would be at least partially sufficient, and now the state says, oh no, none of that's sufficient, shows not only the lack of willfulness, but it also shows that 390 is void for vagueness, when three different entities of the state themselves disagree about what magic words a doctor needs to use. So 390, even without their viability saving construction, is certainly unconstitutional.
Judge, I don't think that's one of your strong arguments. I might move to...
Okay. But the point is that the written certification requirement, not only are the charges here flawed because they neither allege nor prove that he willfully violated that one. Furthermore, as applied here, it's unconstitutional. Well, on its face, it's unconstitutional as void for vagueness because there's no rules. ACCA's never promulgated any rules, and no physician can know what words they have to write to comply. I see that I'm just about now at my rebuttal time. If you have another question, I'd take it now or can wait for rebuttal.
Okay,
thank you, Your Honor.
Morning. Just ask you to... Is that your argument, that the statute should be construed only to apply to viable fetuses?
Yes, Your Honor. Your Honor, Craig Fieser from the Florida Solicitor General's Office on behalf of the Department of Health here. Our argument in the brief as to the viability issue, the statute certainly draws a clear line at 24 weeks. That's what it says. Both of the statutes, 797 and 390, both talk in terms of 24 weeks, third trimester. The seminal case here, these are Florida constitutional challenges, and the seminal case here is obviously the TW case, which talks about the state's ability to regulate, perhaps even prohibit third trimester abortions, and as the way the Florida Supreme Court described it in TW, abortions after viability, which it explicitly discusses as being in the third trimester. In fact, the Florida Supreme Court talks about 24 weeks as sort of being, at least at that time, that case was 20 years ago, but at that time the court was saying we don't foresee even in the future that viability is going to even move from 24 weeks. So it really specifically talks about the third trimester. So our argument in our brief is that what we're talking about here are viable fetuses. We're talking about late-term, rare abortion procedures in the state of Florida that very rarely occur.
Is there anything in the record anywhere where a determination was made by the fact finder as to whether or not this fetus was viable at the time?
There is not, Your Honor. There's nothing that I'm aware of where the ALJ determined viability. There is testimony from the appellant's experts that, and certainly there's some evidence in the medical records from the treating OBGYN that there was some severe.
Would that make a difference as to how the case was analyzed as far as what the court or what the agency was going to do?
It would not, Your Honor. Again, this statute defines.
If you have a fetus that's not viable and that's proven as a fact during the third trimester, is there still a compelling state interest to regulate or control the abortion?
Your Honor, of course that's not this case, and I would argue that because here we have facial constitutional challenges to strike the entire all of 797 and all of 390 in relation to third trimester abortions, that's not an issue that this court needs to decide. There may be situations where as applied in certain cases where there could be constitutional issues in terms of emergencies or health issues or non-viability issues. That's not the case here. And in fact, the United States Supreme Court, and I would point this court to the Ayotte case, which is a 2006 case, one of the last cases that Justice O'Connor wrote, where she talks about, and in particular in the context of abortion statutes, the court should really limit its constitutional decision to the problem at hand. Facial invalidity or striking down statutes on their face is a pretty extraordinary and extreme remedy when there may still be some constitutional applications of a statute that may actually be consistent with legislative intent. And in that case, the court actually remanded the case back down to the courts below to decide, how could this statute be applied in a constitutional way? If it is applied in some circumstances in an unconstitutional way, can we sort of sever the two and still have a statute here that would comply or be consistent with legislative intent?
Let me ask you to address issue one and the fact that, let me ask it this way. 456, the 1K and the 558, 1G, I'm leaving off part of the statutory reference, but do you have any instances, because I didn't see any, where the department has prosecuted a crime other than a sexual misconduct which is separately provided for under those provisions, a DUI? I mean, I don't know what, but any criminal conduct?
I don't have any specific cases to cite to the court, and we don't. And opposing counsel is correct. We don't cite any in our brief, and neither do they. However, in terms of the plain meaning of what G and K both say, as Your Honor has pointed out, they both say any statutory or legal obligation placed upon a licensed physician. That's one of a litany, and especially in 456. I believe it goes all the way up to double N.
What about the argument that the statute also tells you what to do with information about a crime committed by a licensee that's not specifically set forth? It says you shall refer it out. Doesn't that suggest that that's the legislature directed that be handled by the prosecuting authority and not as a licensing matter?
I think it suggests the first thing that you mentioned, Your Honor, that there is a requirement for the department to report and to assist and to forward and do whatever it can with the prosecuting authorities when it believes a crime has occurred. That's not mutually exclusive to potential disciplinary proceedings. None of these subsections in 456 or 458 are mutually exclusive. Any one of them could be a basis for charging discipline, and it plainly states in G, N, and K that any statutory legal obligation can result in an administrative complaint and an administrative proceeding, which is what occurred here.
It would have been clear if the statute said any crime.
Yes, Your Honor.
They do have an argument. Failing to perform a statutory duty does suggest something other than criminal conduct, perhaps, doesn't it?
I don't.
Affirmative obligation. Because the statute generally prohibits conduct. They don't impose necessarily affirmative obligations like a loan repayment or something like that.
Yeah, sure. I don't think that the statute necessarily suggests that something couldn't also be a criminal act, especially if it's performed with the requisite criminal intent, etc. It doesn't. I don't think. Again, I don't think those two things are mutually exclusive. Here you have two statutes here that I think are clear legal obligations on physicians or anyone performing a third trimester abortion. It has to be performed in a hospital, and it has to be performed after the necessary consultation with another physician and certification from another physician. Those are legal obligations that the legislature clearly intended to place on those who would perform third trimester abortions, such as Dr. Pendergraft here. G and K are certainly under the sort of the plain language are catch-all provisions of this statute. They could potentially catch a lot of things that are also criminal acts under Florida law. And in fact, some of the other subsections of 456 and 458 itself that are listed could also be potentially charged in a criminal context. There's coverage for things like fraud and misrepresentations and soliciting from patients, all kinds of things that could also be covered by criminal laws, but are also subject to separate disciplinary proceedings. That's what occurred here.
How does the burden of proof come into play with that? If we accept the appellant's argument, they have to be convicted of a crime beyond a reasonable doubt before they can be charged with failing to perform any statutory remedy where the burden of proof is clear and convincing?
I think that goes back to what Judge Lawson raised before, which is subsection C of both 456 and 458, for lack of a better way of putting it, make it easier for the department to actually bring disciplinary charges in that there's already been a conviction, there's already been a beyond a reasonable doubt standard of proof that this particular physician or licensed professional committed the act that is the subject of subsection C. If it's subsections G or K, it's an actual ALG disciplinary administrative proceeding which has a clear and convincing evidence standard of proof that the person violated some sort of legal or statutory duty that was put upon them. That's what occurred here. The department here did not charge under subsections 1C of either statute. The department charged under subsections G and K, which obviously it initiates the entire administrative proceeding here and all of the due process that goes with it. Here you had
Let me ask you this. I guess I really don't understand the argument that, okay, we get to prosecute any crime under G and K, but we don't have to prosecute every element of the crime. We don't have to prove willfulness. I mean, if that is just a catch-all that allows you to take criminal conduct and then prove it, even under lesser, I mean, I'm not suggesting that you'd have to prove willfulness beyond a reasonable doubt because this is a licensing context, but how can you eliminate part of what's prescribed in the criminal statute and say, well, we just don't have to prove that part of it, if your argument is we're taking that statute and prosecuting it as a license revocation matter?
Respectfully, Your Honor, I mean, if you start by looking at the criminal acts as they're defined in sections 797 and 390.0111, I believe it's subsection 4 of 797 talks about a willful violation of this particular prohibition, meaning you don't do it in a hospital, can result in a misdemeanor charge. And I believe it's subsection 10 of 390 talks about a willful violation of this particular statute can result in a felony charge. Okay. That's different than the general legal duty and obligation that is placed on a physician under Florida law to perform this particular procedure, this particular abortion, in accordance with what the legislature has said must be complied with. That's why the department would charge under G and K and not necessarily have to prove criminal elements. The actual criminal process is a separate thing here, and Your Honor raised the issue of due process. Due process was certainly provided here. It was an administrative proceeding, clear and convincing standard of proof, discovery, continuances, formal hearing before the board, everything. The doctor here was given every opportunity to be heard, every opportunity to present its particular case to the Board of Medicine before discipline is imposed. Discipline in an administrative context is different and separate from a criminal charge, a criminal prosecution. And therefore, the whole idea of willfulness is relevant to a crime, but it's not necessarily relevant to the administrative proceedings that occurred here.
Counsel, is the disciplinary action on hold pending this appeal?
Your Honor, I believe the actual administrative suspension has been stayed. The costs that were imposed were not stayed, but the administrative suspension was. So just to reiterate here, this is I think is exactly what Judge Lawson had said. This is an issue of the plain meaning of sections G and K, and the department's decision to charge under specific subsections of 456 and 458, which it did here. It can choose from a litany, really a laundry list of different charges it could impose against a licensee. If I could just briefly address what I believe opposing counsel was about to address, which is the constitutional issues. I think they've been sort of alluded to a few times here. This is a facial challenge, as I've already mentioned, to two long-standing 30-year-old requirements, not prohibitions. And as Your Honor pointed out, there's been certainly discussion in federal law and in the seminal Florida case here that says this late in the pregnancy, a state could potentially forbid an abortion altogether. That's not what these statutes require. They require for the health and safety of the mother, and as the Florida Supreme Court and the federal courts have recognized, the life of the unborn child at this late stage of the pregnancy. These statutes require that an abortion be performed in a hospital, and that one other physician, both physicians, consult as to whether or not this is necessary for the life of the mother. The consultation did not occur here. Perhaps the ALJ found here, the administrative law judge found here, that perhaps Dr. Pendergraft's notation could be considered something that might meet Section 390.0111. We aren't necessarily sure if it's even clear that his does, but even if his does, there's no second certification at all. There's a brief mention by Dr. Pendergraft that the treating OBGYN, agrees with what I'm saying here, agrees that there are health issues here. There were multiple abnormalities in this fetus. There was a lot of discussion amongst doctors and with the patient here, and there certainly is expert testimony at the hearing that they may or may not have caused fetal demise during pregnancy or shortly thereafter, which obviously poses a health risk any time that occurs. But there's no finding here that this is necessary to protect the health or life of the mother. There's certainly no certification of that, and there's certainly no evidence that this was any kind of a medical emergency. In fact, the patient here took a pregnancy test somewhere around the middle of June. It came back positive, obviously. Found out maybe a week after that through ultrasound what was going on and the different abnormalities. Two full weeks before this actual abortion occurred. So there's no evidence at all that any kind of a medical emergency occurred. This is not the case to decide that facially these requirements for the health of the mother, health and safety of the mother, and for the health and safety of the potential unborn child.
Counsel, was there a constitutional challenge made during the administrative law judge's hearing?
There was not, and Your Honor, that's exactly what I was about to say. This is not the case. So
you didn't preserve it. Is that your argument?
Well, they can't raise the constitutional issue below, correct? They just have to put in any factual matters that they need in order to make that's the law, in order to make the argument here, correct?
Correct, Your Honor. The first district in the Rice case, and I believe there's some other courts as well that...
So you're not arguing that they can't make a facial constitutional challenge. You're just arguing that they can't do things like say, because there aren't any hospitals available, this is a problem because they didn't put any evidence in the record to show that there are no hospitals available. That you say that they didn't make the record that they needed to make the kind of constitutional arguments they're making here.
That is exactly what we're arguing, Your Honor. No one can dispute that under federal case law and under Florida case law, the compelling interest portion of strict scrutiny is satisfied. In fact, it's satisfied double. You have the life and health of the mother, and you have protection of the unborn child. The issue here that seems to be raised by the appellant in the brief is the least restrictive means portion. Clinics are perfectly safe. They're as safe as hospitals. There's no other way for her to get this kind of an abortion. She would have had to go somewhere else.
And below, you tried to put on evidence to address that issue, and there was an objection, and that objection was sustained. So
that
there's no evidence on either side that would allow us to look at that issue.
Correct. And we argue in our brief that, and there's no case directly on point here, but we argue in our brief that because he did that, he did essentially waive it. He essentially, failed to do what the cases say he should have done, which is proffer some evidence. We tried to proffer the evidence. We were actually sort of put on notice during the joint stipulation portion before the actual final hearing that constitutional issues were a part of this case, and said, well, wait, let's stop here. Let's make sure that we proffer evidence as to, again, things like, is there a hospital available if there really was an emergency? How often are these procedures performed in Florida? Things that would pertain to the least restrictive means sort of prong of strict scrutiny. He did object to that, and that kind of stuff was kept out and not raised at all before the ALJ. So this is certainly, we would argue, not the case for this court to decide facially that these long-standing statutes should be struck in their entirety as a whole. And again, whether or not they can be constitutionally applied in this particular case to this patient or in the future is not the issue here, since he is raising facial challenges.
We are running out of time, and I do want to address issue 6, and just it is a little bit disconcerting to me that the board was told that they had no discretion, and that's how I understand the record, but to add the 1-year suspension in addition to the emergency suspension and not give credit for that time. What's your position as to why that's fair and satisfies due process?
As I understand the case law, Your Honor, the administrative law judge makes a recommendation as to what the penalty should be. There is case law that suggests that the board can deviate from that, and in fact has. There's one case in particular that I believe is cited, that we cite, that talks about the ALJ recommended a fairly light penalty, and the board actually revoked the license. I believe that was the case where a doctor had gone sort of a holistic approach, and somebody had died or didn't get treatment for cancer. And the board actually revoked instead of going with somewhat of a lighter sentence. But the board needs to make findings as to why it is going to deviate from the ALJ and why it's going to do something different than the penalty and the findings that the ALJ has made. In this case,
let me ask you this: in the criminal context, and maybe it's not analogous, but in the criminal context, of course, it's a clear due process violation if you sentence someone not to give them credit for time they've already served against that sentence. And it seems like it would be analogous that if you're going to suspend somebody's license and you already suspended it, that are there any cases that you're aware of that address whether it's a due process problem not to give credit?
Yeah, I think, Your Honor, and I'll get the cite. The one that I just talked about, which is actually out of this court, the Clark case, which is 463 Southern 2nd 328, is the case where the board actually rejected the recommended penalty of a 1-year suspension from the ALJ and revoked the doctor's license. Now, in that case, this court said that's pretty harsh. That we may consider that harsh, but it's not within our purview to decide, as long as the board is acting within its statutory authority, what kind of penalties should be imposed here. Here, the board did not have a recommendation from the ALJ to take account of the 15-month emergency suspension, and so the board performed its penalty under its usual practice of saying from the date of this order, the penalty shall be served.
ALJ didn't say don't do that. ALJ just didn't address it.
Didn't address it and did not make any sort of recommendations as to whether there should be credit for time.
So why couldn't the board have given credit?
The board could have given credit if it made some sort of findings or decided whether or not that was an appropriate thing to do.
Weren't they told that they couldn't give credit?
I'm not aware that they were told that they couldn't give credit. I'm aware that they were told that it was not recommended by the ALJ, and if they were going to give credit, they would have to decide, whether or not that was appropriate in this particular case. The fact that they chose not to was certainly within their discretion, and there's no case law. And in fact, that Clark case I just cited is an example of a court saying of this court saying it's not within our appellate court decision making to decide whether or not we should reverse the actual penalty imposed.
That's time. Are there any other questions?
I had a question about the imposition of costs. Was that done?
I'll give you extra time.
Was that done ex parte, or how was that handled?
That was done in the standard way it is always done, which is under 456-0724, in that it is a sort of a separate proceeding after the ALJ proceeding has concluded that is conducted before the board. An affidavit is presented, expenses, attorney's costs. This was all the doctor here was on notice of this from the very beginning. There's an attachment to the administrative complaint that says 456-0724 may be followed in the future if we were to win this case. And that's exactly what occurred here. That's a standard in terms of what the department does.
Thank you.
Any other questions? Okay, thank you very much.
Thank you.
add a minute to your time for that extra time. So.
Thank you very much, Your Honor. I do want to start with a constitutional point. In their brief at page 22, footnote 19, the state says, in this case, the canon, referring to the canon of constitutional avoidance, construing a statute in a way to make it constitutional, to save it from unconstitutionality. Their brief says, in this case, that canon dictates that Florida's hospital requirement in section 797.03, which by its terms applies only to third trimester abortion procedures, should be reasonably construed to cover only post-viability abortions. They are, in fact, saying that it must be construed to be limited to apply only to viable abortions. Well, if that's true, they can't have it all ways. They can't say it's only constitutional if it only applies to viable fetuses because that's the only time the state's interest is compelling, but we don't have to charge and prove viability in an administrative proceeding. If it only applies to viable abortions, then they must charge viability and prove viability in the administrative proceeding, just like it would have to be proved in the criminal proceeding, assuming, of course, they can bypass the criminal system and use, and ignore subsection C. And on that point, Your Honor, the fraud examples that the Solicitor General provided are not apposite because the disciplinary statutes themselves specify fraud as a basis for discipline. Again, in those instances, just like the sexual misconduct, they don't charge the underlying crime. It's very clear here that the legislature's intent was that Section 797 and 390 be enforced in the first instance through the criminal process. They didn't say, well, it's a strict liability offense that you can charge in a disciplinary proceeding under the general legal obligation language and dispense with willfulness, but you only have to show willfulness if you enforce it criminally. Willfulness is a required element. 456.065 says the department shall refer suspected violations of crimes relating to the practice of medicine to the prosecutor, where all the elements apply. The department here is seeking to cherry pick so many selective provisions of so many statutes to construe everything liberally in their favor. But the principle of construction that applies here is strict construction against the department and in the licensee's favor. Now, going back to the constitutionality for a moment, my opposing counsel says that, well, it makes no difference here whether the fetus is viable or not, even though they acknowledge that the state only has a compelling interest.
Well, you're making a facial challenge. I mean,
yes, and that's what I wanted to address. The facial challenge first to 390 is that it's void for vagueness because nobody knows exactly what words will suffice. And there was, in fact, consultation here. The problem was that the department apparently, in
certified
contrast
in
to
writing
ACTA,
does not seem vague to me. That seems to reasonably put anybody on notice as to what's required.
The written statements that actually occurred here where...
And that certification has to say within a reasonable degree of medical probability.
Well, that is now the state's position. It wasn't the ALJ's position, and it wasn't the ACCA surveyor's position. The ACCA surveyor said that some writing on a chart that indicates that in that medical professional's opinion, the maternal health reasons or medically appropriate were sufficient. The state now says only if the doctor writes the exact words of the statute does it suffice. Well, if that's the proper interpretation, then it is facially unconstitutional as not being the least restrictive means. Because if the state's interest here is to ensure consultation, which happened here, and to ensure that there's actually a legitimate health reason, then the normal way the doctor chooses to express, here Dr. Pendergraft said maternal health reasons. And Dr. PC, the referring physician, in a lengthy note, described all the problems and said, my partners and I have concluded this is appropriate. Those are the words those doctors chose in their normal medical practice to convey the sentiment that the state says has to be conveyed. So how is it the least restrictive alternative to say, oh, no, you chose the wrong words?
You're about a minute over your time, and see if there are any final questions. Any final questions?
I don't have any further questions.
Okay, very well argued on both sides. Thank you very much.
Thank you very much, Your
Court's in
Honors.
recess.